4 new handouts for today, your Federal Legislative History Workshop and your group State Legislative History Workshop. For the group, please share amongst the group if I've commented on it. It means that there's something that you missed that you might want to make sure you understand. For instance, a couple of groups forgot that McKinney's Session Laws has 2 volumes, and you actually find the legislative history materials in the 2nd volume. Some of you forgot to check that 2nd volume, so hint, hint, it might be something you want to know. Okay, moving on. I'm going to start out by reviewing assignment 2 at the end of class. I will hand them back to you. That's the statutes assignment, for those of you who don't remember. So remind me at the end of the class not to forget to give those back to you. So first random question of the day. Anybody here have a phone before a smartphone? Are you old enough to have? Okay, I can't keep track of when smartphones. Okay, so when the smartphone came out, you weren't familiar with it, right? You had to learn it new. It was kind of fun, right? Because they're really cool. Okay, so on that principle, a lot of you in your assignments have mentioned that you really liked one service over the other because it's more familiar. And what I am going to tell you is familiarity is not a good reason when you're evaluating something for its effectiveness and efficiency. It's a great reason to prefer something because you like it because it's familiar, but it's not a good reason to call it more effective or efficient, right? Smartphones are a whole lot better than the old version, right? And you had to learn that new, so, okay, point made. Second, Bloomberg. I know it's been difficult. Again, if you use Bloomberg at home, you won't run into some of the problems. Again, I'm still working between Bloomberg and Hofstreet to get this whole IP thing straightened out. But anyway, at home, when you can access Bloomberg without too much trouble, remember, one of the things you want to remember about Bloomberg is it's a flat fee. So while it doesn't have as many features as Luttis and Westlaw, it does have that advantage when you get out into the paying world. The other thing, probably even more significantly about Bloomberg, there's no plain language. Some of you filled out Bloomberg for plain language search, which was okay. I wasn't going to worry about that. But you also did your searches when you did search on Bloomberg as if it were a plain language search. It is not. What Bloomberg will do is it will automatically use the AND connector in between your words. So if you type in false advertising, Bloomberg will search false and advertising. If you want false advertising to be a phrase, it needs to be in quotes. If you want it within the same paragraph, it needs a /P, and that /P needs to be in between the words false and advertising. So false, space, /P, space, advertising. A couple of people got confused about that. More substantively, actually, let me open another Westlaw tab for this. Very important when researching statutes, and I emphasize this as we talked about the tables of contents, and this is one of the reasons you always want to check the table of contents, and that is to check the context, or sometimes referred to as the statutory scheme. Statutes are rarely passed, as we've seen in our public laws, as a single section. There are a few, I won't say never, but usually there are several sections involved in a particular public law or a particular chapter law in New York. So, for instance, here we have a section on labeling, and it shall be unlawful for a person to manufacture, sell, distribute, package of which fails to bear in accordance one of the following labels. This sounds good for our homework hypothetical, but it turns out in the statutory scheme, it is part of cigarette label and advertising. So it even has the word advertising in there, which is good for our topic as well. But this section has nothing to do with, or will not affect our client, because this particular section, 1333, it has to do with cigarettes. So always important, see what your statutory scheme or context or however you want to think about it, critical. Conversely, we were looking at, well, you were looking at in New York, some of you found the sections in the agricultural and markets title. That sounds familiar to a bunch of you, right? That's great. A couple people were confused because agriculture tea has nothing to do with agriculture, at least not this country, maybe countries where they actually grow tea in any amounts, but not here. But yet, if you look at the statutory scheme there, it turns out it's agricultural and markets. And of course, markets is where you sell just about anything, right? I mean, that's one way to look at it. Another way is, and probably, well, definitely a better way, look at the statutory scheme, look at the context. In that context, the agricultural and markets statutory scheme is absolutely relevant, those sections, to your client. Along the same lines, a number of you, which was really good, I didn't ask this, so this wasn't expected, but a number of you discovered, sometimes in New York, sometimes in federal, a couple of times in both, that there are actually two different titles in which we find relevant statute sections. I don't know, a lot of people seem to want to find a single answer. And sometimes there is just one section. But a lot of times for more complex issues, and that's what we're dealing with in class, the simple issues usually resolve themselves. More complex issues frequently involve different areas, advertising and trade in our homework hypothetical. In our class hypothetical, ERISA, so health benefits and labor and insurance. So there are three potential areas. So again, be flexible and don't assume just because you found one, you're done. Another related sort of aspect is in your evaluation, and again, how it was worded, this was fine. Secondary sources frequently, maybe even most of the time, won't give you the exact answer. Sometimes they won't even get you to the right section. What secondary sources will do, hopefully, is at least get you started with terminology. A number of you started using the search term false advertising, which was great, totally relevant. That's not a term you got from the hypothetical because I didn't use it in my description. Might have been one we talked about in our issue spotting, or it might have been one you discovered in the secondary sources without even realizing it. Maybe one of the names of the ALRs was false advertising. I think one of them was. And you picked up on that maybe even subconsciously. So secondary sources are great just for terminology. Secondary sources might get you started. Maybe they'll get you in the right title and in the right subsection. So maybe it'll get you into agricultural and markets in New York, but it won't get you right to the best section. It might get you to a not great section. But then you go to our good friend, the table of contents, and you find, oh, look, there's an even better section. False advertising, just the one I want, even though the secondary source only got me to 2 sections before or 4 sections after. So don't worry so much about secondary sources getting you to the answer. Think about them as getting you a start to the answer. Did that? And likewise, the index. Usually I find the index, especially in statutory codes, don't get me to the right section. But frequently they do get me at least to the right code or one of the right codes. And then it might get me to the not best section, but I go straight to the table of contents and bang, boom, there I am. And it's actually not too difficult or takes too long. Okay, so those are my notes. You'll see I put comments. Again, at the end of class, I'll hand back. You'll see comments. So I tried to spell that out specifically on your papers. Okay, so any questions before So at long last, we come to cases. What all of you have been doing in law school for 2 or 3 years now. And what I'm going to do, as some of you may have, if you've looked in the handout already, is I'm going to first start with a review of what you already know, so we're all on the same page, but I'm going to highlight those important parts of what you already know when you're doing case research. So of course here is our, or at least my, favorite handout, Sources of the Law. We've been talking a great deal about our constitutional Article 1, legislative. So now is time to move to Article 3, judicial. And of course, you're all familiar with this. About the only thing you might not be familiar, and probably, or maybe some of you are some of the abbreviations for the New York official reporters. And we'll be talking a little bit about official and unofficial, as well as what's actually in reporters. So we have the hierarchy of the courts, and of course the hierarchy of the courts is important for that all-important concept of stare decisis. Now I'm not going to go into a definition. You all talked about that at length in your legal writing courses and possibly elsewhere. But a seemingly simple concept of following precedent actually is extraordinarily important, obviously substantively for areas of the law, but also for legal research in terms of finding precedents and following precedent as well as supporting or refuting arguments. And one of those reasons, again, I'm sure you talked about, is the issue of authority. Now, of course, we have the hierarchy of the courts, the highest court, federal, Supreme Court. Whatever reason they name it in New York, the Court of Appeals, I don't know. And of course, you gotta love New York because the lowest court, Supreme Court. We're New Yorkers, so we can say that. So again, you want to keep track of that in whatever state you're in. If you plan on staying in New York, that's probably what you'll worry about much of the time. But when you do find yourself in other states, you want to make sure you understand their system, right? Because they may have as weird a system as New York, so you can't assume Supreme is the highest court, even though it should be. And there's your good friend, the Blue Book, which I'm sure you all know has all of the state rules in it. And the nice thing about the Blue Book from a substantive standpoint is you can actually figure out the state hierarchy in that. So it's a nice, easy place, since you all have Blue Books, I imagine, to see if you wind up having to do research in, I don't know, Connecticut, Montana, Nevada, wherever, I'm just making up states here, check out what their hierarchy is. So as you look at the abbreviations, you know what court, what level of hierarchy you're looking in. Now this hierarchy, the other thing you want to think about back here in New York is, of course, we have the different levels. We have the appellate division, we have the lowest court, the Supreme Court, we have the appellate division, because New York is, or we New Yorkers are litigious, we're a big state, we're a populous state. We actually have 4 departments, as I'm sure you know, of our appellate departments. And you need to think about what department am I in, and if I'm reading a case from another department, is that authoritative? Is it persuasive? And we'll be taking a look at that as in our handout here. So some of you may recognize on page 1, you may recognize this. I understand some of you saw that use this book in legal writing, legal reasoning and legal writing. I like it because I like the explanation of authority. And again, I know you've done this in legal writing, so this is just highlighting the areas that we need to think about as we research case law. And one of the things I like about this particular text is, as you can see on page 2, I have a nice handy-dandy arrow. So basically what we're looking at as primary authority, what we're looking at courts, essentially, that govern the court in which your lawsuit will be decided. So if you're in a Supreme Court in New York, again, the lowest court, looking to what's authority in the appellate division, you would first look to that court that has the authority over your court, has the authority to reverse whatever your lawsuit would be decided. Or in other words, if you're in the Supreme Court, where would your case be appealed to? We happen to be in the 2nd department, so that's the answer. If you're here in Nassau County, so if you're elsewhere in New York, it might be different. Turning to page 3. So, of course, we all know courts only bound higher courts within the same jurisdiction. So, you know, New York, we don't worry about New Jersey or Connecticut. And likewise, the federal courts, U.S. Court of Appeals, binds only the federal district court within its same jurisdiction. And where it gets interesting, well, it gets interesting all over, but as I alluded to, the state Supreme Court, of course, binds states for On issues of state law, there's the Erie Doctrine. I'm not going to review that. You discussed that plenty in Civ Pro. And as you can see, as I mentioned, a state's intermediate appellate court binds any trial courts in its jurisdiction. Some states, like New York, divided to more than one. The intermediate appellate court might bind only those trial courts in its jurisdiction or all trial courts in the state. And actually, I'm going to jump a little bit ahead since you started talking about that to pages 6. And what you see is reference to a New York jurisprudence section, which explains, actually, if you look on page 7, I didn't underline it, perhaps I should have. The second paragraph that starts with the word decisions ends with decisions by appellate term must be followed by courts whose appeals lie to it. So that perhaps says it a little bit better than I did a little while ago. However, and what I did underline, the last bit, a question has not been decided by the appellate court in a certain department. So if we're in the second department and our department hasn't decided, inferior courts in that department, so the Supreme Court, must follow determinations of appellate courts in other departments until such time as their own appellate tribunals or court of appeals passes on the question. So we're getting into subtleties here. I'm not suggesting you try to sit down and memorize every single subtlety. What I'm suggesting is, especially in New York, as you do your research for whatever issue you're researching and you're looking at cases, keep in mind you need to be aware of these departmental considerations. Okay, any questions so far? And then what I liked about this text, turning back to page 4, are just some nice highlighted, bolded rules to be guided by. So within the same jurisdiction, we actually didn't talk about this when we talked about statute. Any new statute trumps any prior inconsistent statute or regulation or decision. A decision in higher court outranks a decision from the lower court if the higher court has the power to reverse, stating the same thing already mentioned. And then turning to page 5, the higher court overrules one of its own prior cases, or if that case is decided in a way that's inconsistent with one of its prior decisions, the prior decision is no longer valid. So again, that tendency to look for more recent cases, and of course the absolute crucial aspect of updating. We'll talk about that with cases next class. Any questions so far? Again, this is a quick run through those aspects of authority and jurisdiction that you want to keep in mind. Now on page 9, it's an incredibly intricate diagram for those of you who are more visually oriented to help you understand the courts in New York and their hierarchy. I would turn to this for very complex questions, but honestly, what I find works better just for me on page 10 is a more simplistic, just to get a sense of the civil and criminal court structures in New York, again, to get a sense of which courts have authority over whatever opinion I might be reading. And on page 11, you'll see the breakdown of the judicial department, so you understand which department, if you are not in Nassau County, in the second department, and one of these other counties. Some of you may wind up practicing in the city, so one of the boroughs. So then you would be in the, you might be in the second or you might be in the first, depending on which borough. And then on pages 12 and 13, we get to case reporting. And when we talk about the hierarchy of courts, and then when we talk about cases reported, we're talking about cases that are officially published. And this actually is an important distinguish. So we see on page 12, cases are published within we see the division of the circuits, and we see on page 13, not 12, with regard to where cases are published in the national reporter system, so this is state cases. And the reason the concept of published is so important is that not only is not every judicial decision published for every case that comes before any given court, but actually a very small fraction of those are published. Imagine you've run into this before when you talk about legal writing. There are lots of decisions. I saw a number somewhere where only about 10% of cases that come before any given court are published. Now, that's not true of the Supreme Court, the United States Supreme Court, but it is probably true, if not a high estimate, of the New York Supreme Court, which, again, remember, is the lowest court in the New York system. So what happens is there are lots of cases out there, even written decisions by judges, that don't get published, that remain unpublished. You've run into that, right, before, unpublished decisions one way or the other. One of the handouts I sent around, the New York Times article was actually written last year, but still particularly interesting. I think might be worth a read if you're interested in later on. Just going to highlight a couple of areas. But there was a decision, now we're talking a federal decision that was unpublished. And here there's a statistic, 88% of decisions in federal appeals courts are unpublished. And what I particularly liked about this article is how it talked about how technology has turned the term unpublished into a misnomer, because these quote-unquote unpublished decisions are available online. And a lot of attorneys especially run into them in various different resources. New York Law Journal is one. We'll look at that briefly in a little while. You probably have you run into the Federal Appendix? It's my favorite publisher's scam by West. We'll talk about that in a bit. So again, interesting on how the concept of unpublished and why judges, especially federal judges, appeals judges, might want to keep an opinion unpublished. Here in New York, what happens is typically a judge or a particular committee will determine whether a case gets published. In other words, gets put into the official reporters. Here in New York, there's this website. Again, this website there's a link on the TWEN site under class web links, and this website actually talks about what the rules are considering publishing. Again, putting in the official reporters particular judicial decisions. So here we see the list: precedential significance, novelty, public importance, practical significance, and you can read the details here, or again link to it later if you're interested, about what all of that means. What it means from a research standpoint is that a very small percentage of cases wind up in one of these reporters. But you will run into a lot of unpublished. And what do unpublished look like? Most likely you will run into them on Lexis and Westlaw, because that's probably what you're going to use mostly, one or the other, maybe if you're lucky both. So here on Westlaw, here's an example of an unpublished decision. How do I know it's unpublished? I know it's unpublished, unfortunately, not because Westlaw gives me a nice big banner, but it does say up here at the top, in not particularly large print, only the Westlaw citation is currently available. And only the Westlaw citation is currently available, even though it's from 2012. So you can see that up there in the citation or down here. And because 2012 is now, near this April 4th, is just shy of 4 years ago, what that's telling me is this is never getting an official citation. I am never going to see a quote-unquote book citation. And by quote-unquote book citation, again, I mean either the New York Reporter, New York Sup, Appellate Division, again, New York Sup, or miscellaneous, again, New York Sup. New York Sup is the unofficial for New York, of course, and this miscellaneous Appellate Division and New York is the official. Just a quick tip if you didn't know this already. One way to tell if a state's reporter, A, is official and that it's the highest court, is it usually just has the state abbreviation. So NY, with nothing after it, is the highest court for New York. If you see CONN with nothing after it, that's the highest state for Connecticut. And that works pretty much with all the states. If you see CONAPP, or here we say AD3D, which you don't even know is New York unless you already know it, that's no longer the highest court. So NYS is not the same as NY. NYS is New York Sup. Actually, sometimes you'll see it abbreviated NY Sup. So just a quick tip. So back to our Westlaw unpublished case. This isn't a New York case, but it would look the same. This actually is a federal case, as you can see. But again, it would be an older case. So it's not like it's a brand new case. It just doesn't have an official site yet. We'll look at one of those in just a second. It's an older case, and there's no official site. That's how I know this is unpublished. And also, I see this only the Westlaw citation. And quickly on Lexis. Same. Well, this is where it gets interesting, as I alluded to earlier. We see just the Lexis site, but and this is what confuses people legitimately, and I have a big beef with West Publishing Company, now Thomson Reuters, on this. There is now what's called the Federal Appendix. West Publishing, now owned by Thomson Reuters, figured out, all these lawyers are always looking for that perfect case, right? And they don't care if it's published or unpublished, they want that perfect case. There's money to be made. So they decided to take these unofficial cases, these unreported cases from Westlaw, from all over the country, and put it in a new bound set called the Federal Appendix. So they made all their money because all we libraries realized, oh gosh, we got to buy this now because everybody's citing to Federal Appendix. So they made the money off of us libraries. I don't know how many law firms have bought it. But you all now see what looks like a very official site, Federal Appendix. It isn't. It is to unreported cases. It's also unofficial. It's published by West. But it does make looking at the cases all the more, I think, slightly confusing. So you just have to, again, be bibliographically aware and look closely. Lexis, at least, gives us this little notice. Please refer to Federal Rules of Appellate Procedure governing their citation to unpublished opinions. So that is a big clue, I think, that, hey, this is unpublished. And speaking of rules, you need to be aware of what your jurisdiction's rules are for publishing, or not publishing, for citing to unpublished opinions. Do they have any authority? Depends on your jurisdiction. There is a particular federal rule, I believe it's actually this 32.1, that says that you may cite to it. I don't believe it has authority, but honestly, you better check your jurisdiction and check the federal rule. States have their own rules. There's this very nice chart. The only bad thing about this, well, two bad things about this chart. One, there's no date on it. So as far as I can tell, and I tried to look into this, I spent a little while looking into this. As far as I can tell, it is from 2007 or 2008. So it's a little bit out of date, and I haven't found anything more recent. But there is this nice chart. Again, the link is on the course website, letting you know what each state says about unpublished opinions. So it lets you know whether precedent, and it gives you the rules. So the nice thing about this chart, it may be outdated, but it should be fairly easy to update by taking the rule and checking out the rules for your state. But be aware when you're citing to unpublished opinions, what the rules are for citing and what the precedential rules are. Okay. So when cases actually do get officially published and are precedent of whatever level and value, there is a process. And the reason I tell you this print process is that you will still see the terminology online. So in the old days, you first had what was called a slip opinion. Anybody know that term? You've heard that term? Okay, see, some know, some yes, so it's good we're going over this. And it's called a slip opinion because it looked like this, a little slip of paper. This one is from the Supreme Court back in 2008. We no longer get these in this library. I very much doubt anybody gets them anymore because you get them online, especially the Supreme Court, same day. If you're interested, I'll pass this around for historical interest. Then the slip opinions, well, they used to get transferred into a softbound called advanced sheet, but I wouldn't worry too much about that. And then they finally get transferred into the hardbound volume. So you actually see reference to slip opinions. So here's a different page on that New York reporting website. Again, the link is on the twin page. To New York decisions available online. And they actually refer to the New York Slip Opinion Service. And what that will typically refer to are very current opinions. So if you see slip opinion these days, it's not going to be one of those little pieces of paper anymore. It's really referring to the concept of, hey, this case just got decided. So, for instance, what that looks like somewhere here on Westlaw. No, Westlaw logged me out. I hate it when they do that. Okay, bear with me. I'm not sure. So, here on Westlaw, I did a search, actually our favorite liability HMO search. We'll come back to this in a little while. But I've now sorted it by date, so I can show you a very recent case here on Westlaw. And notice it actually says slip copy. But you can see it's 2016 Westlaw, whatever the number is. We see it's pretty recent, within the last month, going into this case. Again, it says only the Westlaw citation is currently available, but that may be because it's such a recent case. We actually don't know, looking at this, whether it's going to be reported or not. So that's why I say looking at it, and you must look at the date. If it's 2012, you know it's not going to be reported. If it's less than a month old, we don't know yet. So right now, this is the only citation that we have available. Similarly, on Lexis, again, I'm going to have to, I've already sorted this one. Again, you can see the same thing, March 8th. So that was what? Today. And you can see 2016 New York app Lexis site as opposed to a Westlaw site. The Lexis sites look a little different, but it's got the word Lexis in there, so that clues you in. Again, we don't know whether this is going to get an official site or not, so we don't know whether it's going to be reported or not. We see this notice, decision text, first available text from the court. It has not been editorial reviewed. So again, another example of the need for bibliographic awareness and just looking at the cases and looking at the citations and understanding what they're telling you in terms of being published, not being published, maybe be published, because we don't know with these very recent ones quite yet. So that's where cases are published when they're very new on the court's website, Lexis Westlaw. When they are very old, and yes, you will run into very old cases. I think I told you the story when I was back while the earth was still cooling and I was working for a law firm. I ran into an issue where the controlling case was 1880-something or 1860-something, doesn't matter. It was a long, long time ago. So there are old cases that are still relevant, and you might run into them. The thing about some of the super-duper old cases is that their citations are funky looking. So if you take a look at page 14, Supreme Court cases way back in the late 1700s into sort of mid-1800s were actually cited to by what are called nominative citations. Nominative meaning named, or they're referred to as nominative reporter, nominative meaning named. So basically these people, men really, sat down in the court and took notes and then reported their notes. So you see an example here, the example here, there was a guy named Dallas and Cranch and Wheaton, and they all did reports over the course of not quite 100 years. Eventually, they were all transferred into the U.S. reports, which is what we now know is the official source for U.S. Supreme Court cases. what you will tend to find, you will see some like older, if you read an older Supreme Court case, they might not give you the U.S. site. They might actually only give you the nominative site. So you might see just a 1 Dallas or a 12 Howard or whomever. But you can see you can kind of figure it out because on the spine of U.S. reports, it actually tells me who the name was. So who the guy was who took notes and published the decisions for the time period covered by this volume. Like, same thing happened in New York. Any of you, again, with historical interest, if not, just send it around. New York's, of course, because we're New Yorkers, is much more complicated. So there's all these overlapping reporters for different time periods and years and different volumes of what became the official New York reports for the highest court, which of course is now the Court of Appeals. And on page 15 and 16, you see that complex overlapping list of names and dates and volumes of New York reports. I give this to you only by way of illustration. I sure don't remember all these. I can't imagine you being interested in sitting down and memorizing it, but have that if you are. The main point of this is when you see a weird site that looks like a name, that's because it is a weird site with a name. And what that tells you is, and you'll probably see the year anyway, A, it's an old case, and B, you probably just have to, some of the names you can plug into Lexis and Westlaw and it comes out, and sometimes it doesn't. So you may actually have to go to the old-fashioned books to find it. You could probably find it by name, but just understand, again, in my theme of bibliographic awareness, what you're looking at. So I'll pass the New York along this side if you're, again, interested in historical reasons and for dust. It's not too much dust left on that, except on the top. Okay, so that's just any questions about published, where you find the order of publication, what the citations are telling you? Okay, so let's quickly review the parts of a published case. And this becomes important for when we talk about finding cases. And I pull up a favorite case, Fisher v. Lowe, which starts with a wayward Chevy struck a tree whose owner sued defendants 3. He sued car's owner, driver 2, and insurer for what was due. Yes, it is in verse. And to me, the best part of this case, and we'll talk about the parts, what they're called in a moment. Headnotes, and we'll talk a lot about headnotes. Defendant Chevy struck a tree. There is no liability. The No-Fault Act comes into play as owner and the driver say. So they wrote the headnotes in verse 2. And the reason that they did this is because, as we scroll down past the headnotes and get to the opinion, and our judge, who clearly has a sense of humor, I wish I could have met this person, starts out his opinion. We thought that we would never see a suit to compensate a tree. So the judge wrote, I don't know why, but the judge wrote the opinion in verse. Now, the verse part isn't what we're going to focus on, unfortunately, maybe. What we're focusing on in the part is that you need to distinguish the actual opinion. Now, this was written by the judge. This is the part, of course, you're going to cite, if you would ever cite to this case. What we were looking at up top is actually known as the summary or sometimes syllabus. So this part, even though it's the first thing you see, was not written by the judge, even though it happens to be in verse. Whoever wrote this had a sense of humor along with the judge and was playing along. Actually, just a funny story. These summaries and the headnotes are written by West editors. And a long time ago, I had an opportunity to visit the West plant out in Minnesota. And it was a bunch of librarians, of course. And somebody, of course, asked about this because we all love this. It's fun to look at and teach. And the funny part was the West person who was taking us around and we're sitting down. He said, oh, could you tell us who wrote the great headnotes from Fisher v. Lowe? And this person was serious. Well, that person we don't really talk about that anymore because that really wasn't approved. They were so serious with zero sense of humor, which made this all more fun. Anyway, so again, you don't want to cite to the summary or syllabus, even when it's fun, unfortunately, because that's not written by the judge. That's not the opinion. And of course, we have the head notes. And as I hope you remember from first year, these are the numbered paragraphs that tell us what the legal issues in the case are. So head note number 1 talks about automobiles and process. We can click on the one and that brings us to where in the case it talks about this particular issue. And then finally, of course, we've got the judges and the attorneys and then the opinion. And occasionally footnotes as well. Okay, in terms of other published decisions, there's the standard places we all know, federal and state, but there are a few specialized reporters you may or may not have encountered. And the best place to see that, come back there. So here's an example of a case where you see this. These are all the different places where you will find this very one single case. So there's the U.S., there's the unofficial Supreme Court reporter, Lawyers Edition, there's the Lexis site, there's the U.S. Patent Quarterly. There are specialized reporters. Sometimes there are some cases that only appear in these specialized reporters. You might have run into FRD. Anybody know what FRD is? Federal Rules Decisions. Has to do with the civil rules, the federal rules of civil procedure. Basically, there's so much litigation on the federal rules of civil procedure and all the different aspects about it. It's why there's a whole course, basically, CivPro. I know you talk about more than just the FRCP, but that the publisher, again, West, decided, and this wasn't to make money, this actually makes some sense, the publisher decided not to include it in the standard trial court reporter, of course, which is the federal supplement. They took out the federal rules of civil procedure cases and put them in the FRD, Federal Rules Decision. So that those are reported cases. They just appear in a different volume because there are just so many of them. Another example is the bankruptcy court. Because it's so specialized, the bankruptcy court has it's basically abbreviated BANKR. It's just the bankruptcy reporter, or BR, which makes a lot more sense. So there are these specialized reporters that if you're practicing in the area, you would get to recognize fairly quickly. The other place are loose leaves. So actually, so as well as some cases are reported in particular states' legal journals. And sometimes that's officially reported cases are in the state's legal journals, and sometimes that is unofficial. So that's not what we want. So we in New York will find a lot of cases that are reported in the NYLJ, New York Law Journal. Remember, we saw that when we talked about legal newspapers. The NYLJ sort of has two functions. It's a legal newspaper and talks about the legal news in New York. It sometimes has substantive articles about areas of the law, which are great as a secondary source to introduce you. And the NYLJ also has cases. The NYLJ at present, well, it's available on its own website, but it's also available on Lexis, not Westlaw. That can change. A few years ago, it was only Westlaw and then Lexis. It depends. It's a business deal, basically a business arrangement. So for now, we go to Lexis when we want to look up the NYLJ and we don't want to go to their website. And Lexis has chosen to divide up the cases. It's created a separate database for the cases for the New York Law Journal. So again, just be aware, if you're seeing a case from the New York Law Journal, if it doesn't have another citation and it's kind of old, it's not reported. So the same rule applies. If it's very recent, it might be in the New York Law Journal, but then it might also become reported in one of the New York, or possibly federal, because the New York Law Journal also reports on federal cases in New York, if that's relevant as well. Okay. Any questions about cases? So I know it's a somewhat long background, but we will come back to all of this as we talk about case research and finding cases. Okay, why don't we get started with that? So, strategies for finding cases. On Lexis, on Westlaw, on the web generally, Google, wherever. We'll talk about Google in a little while. Of course, there's our favorite keyword search. That's kind of our familiar old pre-flip phone, before smartphone. We know we all do that. And sometimes that's perfectly fine. That's great. You'll jump onto Google, you'll jump on Lexis or Westlaw, you'll type in your keywords, and boom, you'll come up with cases that are relevant. And that's fine. What we're going to talk about now are more tools for your toolbox when that first attempt isn't so fine. It doesn't work. So I'm not trying to talk you out of Googling first. I'm suggesting Google, see if you find something useful. And if you do, great. Although honestly, if you do, great, but I still, depending on what you're doing, I wouldn't stop there because Google is very limited. So in addition to just keyword searching, another strategy that we've we've definitely already run into are topical strategies. And topical strategies is a fancy way of saying, let's look for cases on a particular subject, which is really what you're doing with keyword, but you're using keywords. With topical, you're using sources that are created to help you find cases on a particular area. So you might ask yourself, why bother? Googling's great. I know, okay, I don't have to stop there, but why even learn all these other crazy tools out there? We're going to get into some weeds here, especially when we go on to Westlaw. And my answer to you, you're asking why bother, is drunk bicycles. We saw this before. Those of you who were in the FLS program, or still are in the FLS program, saw this example with Professor Selby. And one of the examples she talked about and actually had you do some work on was finding cases having to do with someone, whether or not someone could be arrested for being drunk on a bicycle. And one of the leading cases, Professor Selby told us all, was in New Jersey, or she set this in New Jersey for whatever reason. So I've limited Google Scholar to New Jersey. One of the leading cases was State v. Johnson. So as you can see, I typed in drunk bicycle into Google Scholar, and I'll talk about Google Scholar in more detail in just a minute. And you see, not maybe the top two, but what are we, 6, 7 down? At least on the first screen, we find State v. Johnson. So all's great, right? Google's great. We found one of the leading cases. Some of these others might be good. But I think, we talked about this example when we were talking about keyword searching, but I did want to go over this specifically again now that we're talking about case finding. But so depends kind of sometimes how someone presents the issue to you. I know it's true for me too. So I could have said, okay, what about if somebody's drinking on a bicycle? Are they going to be criminally liable? And the first thing you might do is type in drinking bicycle. And it's actually, Professor Selby did this in one of the sections, because that's how she started talking about it. So she threw in drinking bicycle. And we get very different results. And not only very different results, but at least on the first screen, we don't even see State v. Johnson. Now, if we take Professor Selby's word that State v. Johnson is a leading case in New Jersey, and I'm taking her word for it, because she's used this a lot, I'm not finding an important case, at least not on the first. I don't even know if it's on the second or third screen, but most people honestly don't get to the second or third screen of Google. So here you see an argument, I hope, for why as great as Google is, you don't want to stop there. You need to use other methods. Now, those other methods may be keyword on Lexis and Westlaw, because honestly, Lexis and Westlaw are better at this problem than Google are in terms of translating drinking and drunk is really the same concept, right? If you're getting on a bicycle after consuming alcohol, you're either were drinking or you are drunk. So it's really the same concept. So that's kind of a long roundabout way of hoping to convince you that you can start a Google, but don't stop there. So one of these strategies that can be particularly useful, in addition to your keyword search on Google, in addition to your keyword search on Lexis and Westlaw, is what's called the one good case approach. You may have heard this in legal writing. If you were in the FLS program, I know Professor Selby mentioned it there as well. But we are going to go into depth because basically the great thing about these topical systems are that once you find that one good case, it will lead you in a variety of different ways to many other good cases. So your real challenge typically is finding that one good case. So, do we remember ways of finding cases? It's pretty much, if you look at the syllabus of the course and what we've been talking about, what are the methods we've done so far where we found cases? Not a trick question. Secondary sources, thank you. Another good way. Notes to decision, case analysis, case notes, whatever your system wants to call it. Absolutely. And of course, as we talked about, keyword searching. So those are all great ways to find that one good case. So why don't we take an early break, and then we will come back and look at Westlaw and how to use the key number system once we have that one good case. So it's 5 o'clock, come back at 5:10. So I promised you to show you Google Scholar, so before diving into the West key number system, how many of you use Google Scholar for case research? Sort of. Well, it's Google, although a couple things you want to know is, in order to do case research, you need to go to Google Scholar. That's the way I know going there is to Google Scholar. And as we did that for articles, you need to do that for case law. So if you do a regular Google search, you will not be searching Google Scholar for cases. You'll be searching regular Google, which will send you to a whole bunch of different websites that may or may not have your case. Beyond that, what you need to know about Google Scholar is it's like a lot of Google work in progress. So you don't really know how far back they go. You don't really know what exactly they include. So I don't believe they include New York Supreme Court cases, again, the lowest level in New York. You can tell Google which courts you want to search, and it will give you some sense of what courts are available just by the list. So Google knows that I am in New York because my IP address is coming from New York. So it gives me the New York court's choice. And then I tell Google Scholar to search case law and then plug in my favorite search liability, HMO. And I hope by now you'll take my word for the fact that if I search liability and in quotes health maintenance organization, I will get different results because Google doesn't recognize that HMO is the same as health maintenance organization. Even Google, like all our computers, is still stupider than human beings. So you can see there's some ways of filtering and sorting. You can do a custom range, and it might tell you the date. Again, that's one of my pet peeves with Google is you don't know how far back it goes, and again, there can be old cases that are relevant. But as a quick and dirty first attempt to find that one good case, Google Scholar is definitely not a bad place to start. Again, emphasizing to start. Any questions about Google Scholar? The great thing about Google is there's not much to explain. Okay, now let's dive into Westlaw, where there's a whole lot to explain. And the whole lot to explain is what's called the digest system. Sometimes it's called the key number system. Basically, this is West's topic organization of the law, basically, of case law. West started this way back in pre-computer days, I think in 1880-something, John B. West, and as I told you, this is not a course on history, so that's as much as I'm going to go into, but the point being is that this system has existed for a long time and still really is the leading system in terms of topic arrangement for cases. We'll look at Lexis's, we'll look briefly at Bloomberg lets us in, and Bloomberg's, they are trying to catch up to West. West obviously has quite a bit of a head start of over 30 years, give or take. So what is this system? Well, here on the Westlaw homepage, we can look at it because Westlaw has given us a link to key numbers. And it's got its little branded logo, so wherever you see that key, that's the West key number system. We've actually seen that key. We've seen it in secondary sources that are published by West. If you see that little key, West is keying you in, unintended, sort of, to its key number system. If you see it in statutes, West is keying you in again to the key number system developed for cases. And what that system is, essentially, as I said, West has organized all of the law into topics, starting with A, abandoned property, and then 400 and something topics later, scrolling down to Z for zoning and planning, and lots in between. I will explain what these numbers are and why you care in a little while. Some of you may notice the numbers skip around a little bit. So we go from 108 to 110. Don't worry about it. Let West worry about that. It's their numbering system. I'll tell you why you need to understand the numbers. You don't need to worry how the numbering got assigned. So what West has done is it has divided into topics, and then each topic it has divided up into subtopics. So in using this system, you need to know two pieces of information. You need to know the topic, the list we're looking at now, and then within whatever topic or topics, because just like statutes, there are typically more than one topic that could be of interest. Within each topic, you want to know what key number is of interest. And you'll see a key number in just a moment, but I want to emphasize the importance of the two pieces of information, because a lot of people get confused and forget that. Think of an address. You need two pieces of information, right? You need the street number. So if you're looking for 122 Hofstra Avenue, I'm just making that up, you need to know the number, 122, and you need to know the street, Hofstra Avenue. So the key number system works the same way. You need to know the street name, so the topic name, and then you need to know the house number or the key number. One thing you want to keep in mind with this topic list is that the names may or may not be intuitive. So my favorite name here, malicious mischief. What on earth is that? Now, there is an iLink that will tell us what malicious mischief is, but again, it's not exactly intuitive. There are some names that West used to use that they realized maybe we need to change. So labor and employment law used to be called master and servant. They changed that, thankfully, in my humble opinion. But one thing you also need to realize is if you're interested in employment law, you need to think to look, if you're looking alphabetically, you need to look under L for labor. Yes, you can do a Control F if you choose the right name. But I can tell you whatever malicious mischief actually covers, I wouldn't think to look under M for malicious. So again, you need to be a little flexible and understand that the names don't always suggest what they may mean. I mean, here's one, time. We can kind of guess that has something to do maybe with statute of limitations, but I'm not even sure because that's a pretty generic term. Anyway, just pointing out the names may not always be intuitive. So there are a couple of ways of figuring out what the names are that are going to represent what you're interested in. Again, that problem of the English language. There are lots of different ways of saying things instead of really weird ways like malicious mischief. So you can search basically the key numbers to see if you can find your term, but you may or may not do so. And there are two different search boxes on this screen, and I actually do not suggest you do it this way. I will show you how I suggest in a little while, but people see search boxes and they want to plug it in, so I want to show you the differences so you hopefully don't get confused. So up here we see West key numbers. So if we search West key numbers and we search it for, we know we're interested in health maintenance organizations. Hopefully there's not a typo in there. Come on, Westlaw. So the top box doesn't search the key number system. The top box searches those head notes. Remember, I pointed out the head notes in the cases, the numbered paragraphs in the beginning. So Westlaw searches every single head note in every single case in its system for health maintenance organization. So that may or may not be useful, but just so you understand what you're looking at. If you actually want to search the hierarchy of this system, you want to use this lower box to search your term. So you can do the compare and contrast. So now what you see, very different looking, right? You see the different topics. So health is one of the topics, bankruptcy is another topic, insurance is another topic, and then you see the key numbers within that topic that use our different terms. Now, I did not put quotes around my terms, so Westlaw is finding stuff with organization. I'm not exactly sure why it's pulling up all of these particular ones, because there are actually not that many. But this turns out actually not to be a bad search, right? Because we see under health, persons liable, health maintenance organizations. Sounds kind of good, right? So actually, I'm going to peek a little back. So that's 198H. Health, and the number we got is 785. It'll help us, I think, to refer back to that as we go along. So that's one way to find it, but that's if you choose the right words. If I searched preemption here, we may or may not get something good. If I searched managed care organizations, remember managed care is another way, health HMOs are one type of managed care organization. I might have thought the broader term would have made sense to use. I may or may not have gotten anything. Actually, I think I wouldn't get too much in managed care organizations. So again, you have to get a little lucky to use this system, which is why I suggest it's not the best way. But actually, what I want to show you, though, is what that actually means. And what that actually means is within the health topic, so remember we need our address, we need two pieces of information. So the health topic is just assign the number 198H. Again, don't worry about how the numbers get assigned, just understand health is assigned the number 198H. And if I click on that, I get the table of contents of my topic. Always useful to look at. And by the way, when you're browsing this key number system on Westlaw, you don't get charged. Because Westlaw is so proud of it, they want to encourage you to use it without worrying about charge. So I can see the broader breakdowns, just like we see in a table of contents, the broader, so regulation in general, public health, may not be interested in, scroll down, government assistance, relation between patient and healthcare provider, malpractice, negligence, or breach of duty. So there's a general area that we may be interested in, and we see our number 785 falls within persons liable. So I may want to break down several, if not all of these, but I certainly want to check out again the breakdown. So looking at this table of contents for your topic and the subdivision within your topic can be very useful. So we see health maintenance organizations. In this instance, honestly, the other ones around it aren't very useful. So there's no guarantee looking at the table of contents will always be great, but it's definitely worth the minute or two it takes to check. I hate to say this, but it's probably always good to check the in general. I don't know why they use that because I find that totally useless in general. What does that mean? But they put good cases in those key numbers. So you kind of want to check to see, and it looks like them. And look at that. Under in general, there we have preemption. So we now have two key numbers, remember 2 street numbers, to look at in our topic for street name health. So we've got street name is health, the number 607, 785 look promising. So that's essentially the structure of the key number system. So now what happens if I find it, however I find it? Say we did that search I did before, and I find, oh look, 785 health maintenance organizations. Let's click. Westlaw pulls up cases that use this topic and this key number. So there are apparently 73 cases that use this particular topic and key number, but notice we're in all state and federal. And again, this is where bibliographic awareness is very important. You want to know what you're looking at, so we may want to limit to New York and federal. And so within New York, actually, I'm going to change my jurisdiction because I'm never confident that all federal includes the Supreme Court, because we want Supreme Court cases no matter where they originated, right? Even if they originated in Nevada, you know, and pick a random state that's not New York. So let's add that. So didn't change it. So of course the limitation to this strategy of trying to randomly find a key number using the West key number system is that, okay, great, we found 6 cases using this particular key number. But there are probably other cases, right? Remember, we encountered some case names. Anybody remember the case name Aetna v. Davila? We saw secondary sources that cited to it. We run across that several times. And in quick discussion we had about research strategy, note-taking, suggested that if you run across a Supreme Court case, jot it down and come back to it later, because of course it's a Supreme Court case. So we don't see that here. So the risk here is limiting yourself too much to one single key number, because we saw a bunch of other relevant ones. We saw that preemption one, 607, and there might be other relevant ones as well. So the better way, I think, to use the key number system is to start with a keyword search, and you're all comfortable with that. So I didn't want to go to Lexis quite yet, because here we go, there's my key search. So I did our favorite search, liability HMO. At the moment I'm in all state and federal, so let's limit to New York. And I might start limiting to New York, because of course we want New York cases. We've had that whole discussion about authority, but keeping in the back of my mind that I may want to broaden it out if I'm not finding anything good in New York. Okay, so here's our liability New York case and federal. We're looking at cases. And now it turns out, obviously we found over 1,000 as opposed to 6. And somewhere in here should be our Davila case. If not, I did something. yeah, let's just start all the going back and forth. I probably confused Westlaw. So let's just do this properly. I've run into this a couple of times with Westlaw where I think I've limited how I want it limited and it comes up with strange results. So then it's time to just do it over. There it is. So there's our Aetna case. So when you find a case, so the point here and the name of the system is to the one good case system, and the idea obviously is to find one good case. So we talked about Google Scholars, so here's a keyword search. We've run into the Aetna case before, so maybe our secondary source helped us find the good case. Again, we talked about the different ways. So looking at that good case. And mind you, a good case is not something that exactly addresses your issue, because very frequently you won't find any case that exactly addresses your issue. Everybody, students, especially first years, and I know you're beyond that, like to think there's always the perfect case. Well, unfortunately, there's rarely the perfect case. You're lucky, and it's unusual if there's a perfect case. There are cases around that sort of touch or intersect your issue in various different ways, and part of your job as lawyers is to put all those pieces of that puzzle together. So Aetna is an example of that, and then it talks about a Texas statute, which has nothing to do with us, right? But it talks a lot about the issues of ERISA preemption with respect to denial of care or coverage. So if we accept for a moment that Aetna is our one good case, the next step, now that we understand the topic and key number system, is to take a look at those headnotes that give us those topics and key numbers. And actually, let's scroll down in the headnotes to headnotes that are of interest for our issues. So we're not really interested in removal of cases, labor and employment, maybe. So, and the nice thing about the headnotes is it gives us a little description about the issue that's addressed in the case. So this issue, insurance, actually covers 3 different topics: insurance, labor and employment, and states. And it's an individual registered complaining of denial of coverage for medical care because of terms of ERISA regulated employee benefit, no legal duty, so fails within the scope and completely preempted. So this sounds pretty relevant. Not good for our client, but unfortunately, but relevant. So we can now use this system to take a look and see which of these topics and key numbers might be useful for us. And as it turns out, I would say, you may or may not agree, that this insurance. So we had looked at health before, but here's the totally another topic, insurance, but it kind of makes sense, right? Because we're talking about insurance coverage. So here's the hierarchy. Again, that table of contents breakdown. So we have the overall topic, then the subtopic, what law governs, then within that preemption, particular laws, employee benefits, health care benefits, right? Pretty relevant. So using our one good case, we have now learned at least another. Terrible with numbers here, so that's 217H, and sometimes these numbers include a letter, which can be a little confusing. Actually, there is no H. I'm wrong about that. Some of them do, but for our topic, insurance, you can see 217 is just plain 217. So 217K, and then, so we said that's insurance. I'm not going to write that out. And our number is 1117 sub 3. You can think of these parentheses sometimes might be an apartment number in our address analogy. So you might have somebody at 200 Hofstra Avenue, apartment 21. Get that up, of course. Okay, so one So that's the insurance topic. Scrolling down in our head notes, here's another head note, claims by participant, beneficiary under ERISA plan, alleging decisions not to provide coverage for treatments recommended by their physicians. And in this head note talks about violating the Texas Healthcare Liability Act. But here we see that health, and we had discovered this from our other search, but if we hadn't bothered with that other search, because as I suggested, I don't think that's particularly effective, we would have learned about our health topic and our preemption key number through our Aetna case. So we'll do 198H. This is one that includes, that's back to health, and that's 607. Oops, 60, let's do that right. 07. One thing you'll notice if you scroll down Aetna is we learned two great key numbers, but it didn't bring us to that 785. And we will talk about other ways of minimizing that disadvantage, because you bring up one good case, any single case isn't going to have every single good key number necessarily. If you're lucky it does, but again, you can't count on being lucky all the time. Okay. So why not just click on one of these links? So I'm going to open it in a new tab. So again, what clicking on those links will do is to bring you other head notes that use that key number. So we clicked on the insurance, the 217 insurance 1117 sub 3. So here are the head notes. But again, bibliographic awareness and Westlaw will always do this. Whatever case, you're looking at a case and you click on a head note, it's going to bring you to that same jurisdiction of that case. So we were looking at the U.S. Supreme Court, so that's our jurisdiction. We certainly don't want to limit ourselves to just the U.S. Supreme Court. So we want to go to, and again, as I suggested, at least start in New York. Definitely include related federal, because we know that this has federal and possibly state aspects. And so here is one way to find other cases that use this particular head note. So the one good case has brought us to, possibly, we haven't read through even the head notes yet, forget about the cases, but 60 cases can be a bit to look through. And so one of the wonderful things about this system is its flexibility. We really want to read about cases where there was a denial of coverage, right? So we can use within, again, this is searching head notes. It's not searching full text, but we can search the head notes, and we can search for something as simple as denial, or we could do a more involved search with the terms coverage. But let's start just with the word deny, just to see what we get, and it's easier to type. And the nice thing about keeping a search simple is that you don't eliminate possibilities. So if I had typed in deny/P coverage, as I was suggesting, I might have missed this case, because as you can see, the terminology is actually denial of benefits, which is still of interest, right? So keeping it simple has a lot of advantages. And in fact, I would suggest keeping it simple is the way to start, and then if you see the need to make it more complex and to get narrower, that's when you would add search terms. So you can see our Aetna case, as we already know, it has the denial of coverage terminology. Okay, so that's one way of using one good case. Find a good key number, click on it, look at the head notes, search within results if need be. So back here at Aetna, excuse me. Another way to use this, which may or may not be obvious. So looking at another of our useful topics and key numbers, as we saw when we were looking through the health topic, there may be one more than one key number within a topic that's of interest. And as I'm always badgering you, check the table of contents. So the way you do that in this system is if you see the topic, you can see the breakdown, you can click any of the stages in this breakdown of the topic. You can go and look at the key number itself, or you can look at any of the higher levels. So I'm thinking malpractice, negligence, or breach of duty. That, to me, makes the most sense. Health is way too broad, but we're actually interested in the malpractice aspect. So let's take a look at that. If we open that in a new. So this now gives us all of the cases that have any of these key numbers. So 600 to 899. And remember, we had looked at that breakdown. If you needed a reminder, you could, up here, there's this little breadcrumb trail. If you remember, it makes it nice and easy. Or you can go back to the home screen and click your way through. If you don't, and again, we can check and see which of these key numbers may be of interest. And again, when we start to look at the headnotes, we still need to be bibliographically aware and change our jurisdiction because we came from a Supreme Court case, so that's where Westlaw is going to, that's the headnotes Westlaw is going to limit us to, so we want to expand that to New York. And so here, actually, a whole lot of cases, because, of course, we're in a much broader category. We're not in a single key number, we're in a whole range of key numbers, 600 to 899, some of which will be totally irrelevant, some of which may be useful. And we can search within results. So here's an example where I might want to do our more complex search. Learning, of course, that I might want to talk about denial of care or coverage or benefits, because as we've seen, any of those terms can be used. Any questions? And again, I limited to New York because that's what's most important to us for our client. But if I'm not finding anything useful, or if I want to see if there's that perfect case that's on point somewhere else, I could expand my jurisdictions and choose and look at that. So maybe some of you are wondering, okay, so we've seen a bunch of different potentially good key numbers. Wouldn't it be nice to do a search, one search, where I could find cases that had one of them? I might not find all of them because that's probably too optimistic, but rather than do 3 different searches, and the answer is you can do that. And this is where advanced legal research earns its name, advanced. So here are our search results. And of course, as we now know, there are lots of useful filters. We've already talked about search within results, so we can do keyword searching. But we can also filter, and of course we can filter by jurisdiction. We can also filter by key number. The way we do that, let's go down to the key number filter, and then we can scan through. And what this list is in the key number filter is every topic that is in any of the cases retrieved by our search. So our liability HMO search contains however many cases we retrieved, and then all of those cases have at least one of these topics. So we can scan through and say, okay, account not interested. And again, bearing in mind, of course, that some of these names can be funky. I don't know if we're going to find anything malicious in here. But what we will find is health. And even if we didn't know already, we could guess that health. And if we click on the link, it will expand it eventually, we hope. So it expands it to the subtopic. So regulation, I don't know, certainly not government assistance. There's that malpractice and negligence. Now remember, we found that searching the key number search, which I again, don't recommend, but if I had done a regular old keyword search and looked at my key number filter, I would have discovered it, and I could expand it further, and choose any of these. So maybe I want to do person's liable, or back here in health, if I just say, okay, I just want to use this particular subtopic, I just click on add. But I don't know, do they still say this in late night commercials? Because honestly, I don't stay up that late anymore. But wait, there's more. But wait, there's more. If I go home, don't we all want to go home? Got black eye anyway. Beyond health, whoops, not that far beyond health. I can look at other topics. So we discovered the insurance topics of interest. Now, of course, we don't want to search all of insurance because there's a lot of areas of insurance not of interest. And we can break it down to, or we can search all. It doesn't give us the ranges, unfortunately. So we would have to guess that what we're interested in is in what law governs, but actually in the Aetna case, we could have looked at that hierarchy, so we would have known it's Roman numeral 3. And then there's preemption. So I'm just going to go with preemption. I'm not even going to break it down anymore, and I'm going to add that. And I could continue on. Maybe I want to look at labor and employment. Maybe there's a relevant one there. I'm hoping you get the idea. So I click on continue. And then, of course, on Westlaw, always have to click on apply filters. And so now what we have are cases within the jurisdiction we've chosen, whether our narrow New York or broader, that use these particular key numbers. So this is what I like to refer to as the really advanced, way cool key number search. One of your handouts is called the anatomy of a really advanced Westlaw key number search. I just put way cool in there. I wasn't going to be too egotistical there. And what I tried to do with this handout is to give you a visual representation of what all this means. And what you can actually do on Westlaw is, if you are a person who's into lots of control, I won't say control freak, just into lots of control, you can actually type in a key number search, including all of these. And so this is what you would type in. I'm not suggesting you learn or figure out how to do this unless you're interested. So if you're interested, great. If you're not, don't even think about it. What I'm hoping this does is this helps explain to you what the structure is of the key number system is and what we are accomplishing in our search. And so what this search is showing you is we are combining key numbers and combining them, telling Westlaw we want either one of them because we're using the OR connector. And then we're adding search terms afterwards. However we choose to structure those search terms with, complex /p and parentheses and all that good stuff. If this handout scares and or confuses you, toss it. Seriously, this is just meant to hopefully explain and give you representation. If you look at this and it's just like too many arrows and numbers, forget it. Toss it. If it helps you, then I will have accomplished my goal. The other handout, while we're talking about handouts, is I hoped to spell out for you the techniques for finding cases on Westlaw. We're actually not even done yet with the different techniques, and we still have to get to Lexis and Bloomberg, but that won't take very long. And then we do have a workshop. So I'm hoping, again, that this techniques, to the extent that there are any confusion in your notes or any holes in your notes, that this might flesh that out so you can refer back to this. Okay, so any questions about the really advanced, if I may say, way cool search on Westlaw? And again, we just limited by the key numbers. To make this the official really advanced way cool, I would add our search term deny And where's my handout? Since /P. So we already have the key numbers, and then care or coverage or benefit. So here are all the cases that have one of our head notes, at least one of our head notes, and the terms that we want. So this now on the screen is the official, really way cool advanced search. Questions? Okay, there's another much simpler, maybe not quite as way cool in my humble opinion, advanced way to search for cases on Westlaw. And that, of course, is the advanced search. And as we've already talked about, the best way to use the advanced search on Westlaw is to first narrow our content type. So we get those extra fields that are specialized for our content type. So I've narrowed to cases and then gone to advanced. And that's so I get these fields. And you can see. So remember we talked about synopsis or summary. That's the beginning paragraph in the case. The digest is basically the head notes and the key numbers. You can search them together because it kind of makes sense. If Wes has prepared this summary and then put together this digest, maybe you want to search them both. And that's what we used to call in the old days when you had to type this out and didn't have all these nice fields, and SYDI search, and that's why it looks like that. I probably used, did I use that still on the handout? Oh no, I spelled it out for you. Good. I'm trying to get away from the old way. So the synopsis digest approach is another nice, I think, easier way to do this search. And you can put anything you want in this field. You can put a key number if you've discovered that. And this is where, if you are typing in key numbers into your search rather than just clicking on the links, this is where you do need to know the numbers, which is why I mentioned them. And as you see them on the handout, it's another reason for the handout. If you do decide you want to type in key numbers, in order to tell Westlaw, hey Westlaw, search a key number, find me a key number, you have to put the topic number, whether it's 198H if it has a letter, or 217 if it doesn't have a letter. Then you have to use the letter K for key number. Westlaw will not do a key number search unless you tell it to with that letter K. So topic number, the letter K, and then your actual key number. So in our case, 607 or 785, or if we're using insurance, 217K1117 open paren 3, which is exactly what you see on the handout. So we could put that in Synopsis Digest if we want, or if we're using these fields because we really don't need to go way crazy, way cool advanced. We might just want to put in particular search terms, but terms that, so we might want to say preempt, and we should have copied and paste. If we're finding that this is a particular I am going to copy and paste. And what you see is Westlaw is populating with the SYDI. So the old days, you can still see a remnant of it. We're still in New York State Federal. That's okay by me. And let's search so you can see what we get. Again, we're starting to see some of the same case names. We've seen the Doe case a whole bunch of times. So let's just dive in just so you can see what the results will look like and where our terms are pulled from. There we go. So again, the synopsis, sometimes called summary. You see some of our terms here. And again, you'll see it in the text of the head note, again, the description of the issue of law, as well as the hierarchy of the topic and key number. Just so you understand where the Synopsis Digest is going to search if you decide to use that particular approach. Questions on the not quite as advanced or way cool? Now there's some actually other, I think it maybe qualify as way cool features in the advanced search for cases. So I'm just going to go back this way rather than click on back a half a dozen times. And those are just other fields that you might want to know about. In addition to the Synopsis Digest field, there is a headnote field. It's kind of duplicative. I just use the Synopsis and Digest because it's just easy to remember. But the other fields worth knowing about are actually way at the bottom. I'll start with the bottom one, written by. If you want to find cases by a particular judge, you actually can't do this in print. You can only do this online. And you all plan on using online, so that works okay. And the reason why it's worth knowing about this is whether you find yourself arguing before the Supreme Court and want to see what Justice Roberts has said, or you find yourself arguing in a New York State court and know you're arguing before Judge, I don't know the judge's names, shame on me, but Judge K used to be a judge in the Court of Appeals, so you wanted to see what your particular judge wrote, how this judge wrote, maybe this judge wrote another opinion in your area. Wouldn't it be nice to know what that judge said if they did in fact decide a case on your issue or something close to your issue? You can use the written by field, and again with other search terms. So for instance, I will quickly, since it's very much in the news, Justice Scalia. So pull up mostly, so if you wanted to see some of these famous opinions that Justice Scalia wrote, this is what it looks like. And so these are the opinions, and this will include the opinion as well as any dissenting or concurring opinions, at least for the Supreme Court, where we have dissenting and concurring opinions. The other field worth knowing about, and we talked about way back in the first class, words and phrases. Anybody remember words and phrases? I know I took one group who was sort of on this side. I think you've all rearranged since then. Anybody remember words and phrases? Sure you do. No? Matt, you're still, yeah, I do, but I don't want to say anything.
I remember.
You do remember. What do you remember?
I remember words and phrases.
So words and phrases. Were you part of the group that we went down? Okay, that makes two of us. So fair enough. Neither of us remember. Basically, words and phrases is part of the digest system. We went down to the print books. But basically, words and phrases will give you cases that judicially define words. Words, obviously, we've talked many, many times, words are critical in the law, and sometimes the definition of a particular term can be critical for your issue. So words and phrases will give you cases where the judge's opinion talks about the definition of your word. So, I don't know if you all remember, but way back in the first class, I gave you a hypothetical asking you the difference between fact and opinion and what the definition was. And so the group that I picked on, we went downstairs to the print digest rather than on Westlaw, and we looked up fact, and we found a great case to answer that particular hypothetical. So here is words and the equivalent on Westlaw. And what we discovered in that first class, which I subsequently investigated, is that the words and phrases on Westlaw works differently than in the books. And bottom line, what you want to know is it's great to do it online. So if we were to plug in the word fact, I get some funky results, I'm sure. You're going to get the word fact sort of anywhere in the, it's not anywhere in the opinion. You're going to get a much broader set of results on Westlaw than you will if you go in the books. And that's because Westlaw is searching a broader range of text. You can't really just search for fact as defined the way you can in the print digest. So this is one instance where actually the print, I think, depending on what you need, obviously, the print can be more advantageous because searching through 391 cases would get rather tedious, whereas when we went downstairs and looked up fact in the New York Digest, we found a handful and found a good case pretty quickly. But no, if you're not near print books or you're allergic to print, know that you can do it through the advanced searching cases online. So those are the advanced techniques on Westlaw Next, spelled out, as I mentioned, in the techniques handout. Any questions before we move to Lexis? Lexis and Bloomberg are not, in my opinion, nearly as robust or feature-rich. Now, some of you may like that because it's way too many choices and way too confusing, and that's fair enough. But there are some similar topical tools on Lexis, again, to enable us to use the one good case approach. So again, here using our liability HMO search and narrowing to cases, and I've now sorted it by relevance. Let's see if we got our Aetna, and there's our Aetna case again. So again, assuming we decided this was a good case, is it? Come on. Lexis has headnotes also. However, these are not at all the same headnotes as you see on Westlaw, and you will see they look different. It's not our two-part address system the way we have on Westlaw topic and key number. We just have a single topic and then a breakdown within that single topic with a breadcrumb trail. And since we see links, what of course we want to do is find a good headnote that talks about the area we're interested in. So for instance, here we see pension benefits, ERISA, federal preemption, federal overview. Lexis gives us a choice. Typically what you will want to, you can view it in the topic index, and we'll take a look at that in a moment, or you get the document. So you get similar headnotes that use that preemption, ERISA. And again, depending on where you started, you can narrow your jurisdiction. I haven't done that yet here, so I might want to narrow to New York. And that is pretty much the way to use the one good case system on Lexis. There are a couple of other features. So if we go back to our search results, what you will see are practice area and topics. So the topics are the different headnote topics that Lexis has. So here are some of them, or at least, well, actually here are. And there are also practice areas, and the difference, and again, I think this is very much a work in progress with Lexis, is that they try to catch up. Here is the topic list, which if you clicked on that topic link from the headnote, it would bring you to the topic list. So we were looking at pension benefits law, so if we wanted to look at the topic breakdown, this is kind of, and we would see ERISA. The other aspect Lexis has are these practice pages. We'll actually look at these in a little bit more depth a little bit later on in the semester when we talk about research strategies, because this is basically what Lexis does by jurisdiction, but also by practice area, is pull together all the different types of materials. But again, if you could look at your practice area to find cases this way as well. Couple of other features. Actually, in our one good case. So actually, I amend what I said earlier. The headnotes is one way of using one good case. Scrolling down to the headnotes and clicking on the link. Lexis also provides a couple of other tools. Topic summaries. They're very proud of their topic summaries. So if you go to a training with our Lexis rep, she'll point you to the topic summaries. And basically, this is Lexis's attempt to, well, summarize a topic. So you can, if there is one in your case, you can click on the link and decide if any of these look promising. Suits to recover plan benefits. I'm not sure if I would recommend this. For instance, I truly believe Aetna is a very important case. It's a Supreme Court case. It's in this area. I believe it still is controlling law, and they don't list it. But they give you the elements, so it is a place to get a start. So once again, good place to start, but wouldn't end here. I can't imagine how they could not list the Aetna case. But they do list at least, I guess they're focusing less on the preemption aspect and more on the duty of care negligence aspect, which is something we would be interested in for our clients. So this would be useful for that aspect. The other feature, one good case feature, and again, I think this is a little gimmicky just between us, is this legal issue trail. And that I'm just going to show you. You click on Activate Passages, you find a passage that you think is relevant for your issue. So I've decided Headnote 3 is good. So I click on that activated passage. And you can see it's cited the following cases for this issue. So it sort of gives me a summary of what cases in that particular passage are important. Maybe somebody can give you an example of when this would be really great. I'm not sure I know of any. Let's leave it at that. But give it a try if you're so inclined. Although I should say for both Lexis and Westlaw, be aware of cost concerns. If you're within that T number system where we first start out in Westlaw, as I said, there's no charge there, but once you start viewing cases and doing searches, again, depending on your plan and what's included and depending on what jurisdiction you're in, you want to be aware of that, and likewise on Lexis as well. The other aspect of Lexis, which we now have, just as we do in Westlaw, is the advanced search. So back on the home screen, here we go directly to advanced search, and then we can choose cases. Did I not go back far enough? There we go, there's cases. And you'll see the similar setup with the different fields that you can search. And the same rationale applies. You have the written by. Opinion by would be the majority opinion as opposed to any opinion if you're in the Supreme Court. Any questions? And last and probably least, as you, many of you have noted in your assignments at Bloomberg, and I should emphasize, in fairness to Bloomberg, the problems we're having accessing, again, are a communication issue between Hofstra and Bloomberg. It shouldn't happen when you're home, so don't judge Bloomberg based on that. Judge it on once you get into Bloomberg and get to the page, how well it operates. So here on Bloomberg, I would say, other than the keyword search, if you go to search and browse and choose court opinions, I have a hunch I may already have been logged out, but let's see what Bloomberg allows you to do, because Bloomberg is starting to assign topics to cases as well, again, to compete with Lexis and Westlaw. So you can browse those topics and tell Bloomberg, hey, only search in a particular topic. So let's see if they have one for, oh, they do have one for health. So let's go to health. And I already have a search here, so let's see if we can get anywhere with Bloomberg so you can see. And again, it's not to say you have to narrow by topic. And on Bloomberg, you can search to your heart's content. There are no cost concerns. You can look at everything, so it may be worth experimenting. But let's take a look at a case so you can see what Bloomberg's topics look like. So here's our search. And here we're getting into the opinion. And the thing about, as you've all discovered, the thing about Bloomberg is they're rather inconsistent. So I randomly chose this case, assuming we would see the topic breakdown, and we do not. So I'm going to go to a case that I know you will see the topic. Break down our friend Aetna. You never know with Bloomberg whether it's going there or... Oh, darn it. I just got there. Moral of this story is be more patient than I am. Okay, if we don't get there quickly, we don't get there quickly. Any questions while I do battle with Bloomberg here? So you're all good with the many different one good case, how we find one good case and use that approach? Okay, if that's the case. Have a workshop. I'm going to ask you to go through a couple of different of our methods on Westlaw, and then take a look on Lexis, and if you can get into Bloomberg, great. If not, actually, I would suggest skipping Bloomberg and going to Google Scholar before Bloomberg, and then see if you can get into Bloomberg, because it's getting good. Hit or miss, as you can see. Okay. I will wander around for questions. So, a couple of things first. So here we just, to finish up Bloomberg, here you see what a case looks like when it does have, and they call it head notes too, and you see the topic breakdown. And again, you could see the topic path, or you could see other cases if you click on the link. Pretty much same as we already saw. And what I do want to go over on the workshop, I know I'm jumping back and forth, is to hopefully do some battle with. So has the workshop gone around? Yeah, if extra, I'll pick them up. It's okay. So we have a question. As a lawyer, can you be sued if you forget to have to do it? Update, update, and update. And the law you relied on is superseded, so you forgot to update. So what are some of the terms? What are some of the concepts and then the terms? Again, think about the what, where, when, why, how. Think about what class would this question be asked in? Substantively, topically. Ethics. Okay, so what are some of the issues you talk about in ethics that would be relevant to this? Okay, possibly. Just shout out every. So you all have to sit down and think about this question if you're going to do the workshop. What are some of the terms you're thinking of?
Legal malpractice.
Legal malpractice, okay. So the who, what, where, when, why, that might be the what. What's the who?
Lawyer.
Okay. And what are other ways of thinking about lawyers or talking about lawyers? Another word for?
Attorney.
Okay, so these, again, just sort of a little mini practice on issue spotting. There's not one good method and depends on the issue, as always. So we've got due diligence, we've got legal malpractice, we've got lawyers, we've got attorneys, we've got ethics. You don't want to use all of those terms, and again, typically start with a simple search and only get more complex if need be. So you need to decide what are the best terms, what are the key concepts. Any questions?
Will we be searching just New York?
Later on, question 6. Okay, so who has found what they think is a good topic and key number? And that would be, just yell it out.
I think we're talking to attorney and client.
Okay.
And the key number would be 45K 32. So I guess the key number is 32. 14 is that much.
Okay.
I can see it, I just don't know which one's the key number.
Let's put a good key numbers. And attorney and client sound. I think there's a 3214 because I don't think it goes that high. And it stays in the 3 digits.
Yeah, I don't know. I guess maybe 32. Yeah.
Oh, 32 sub.
Oh, yeah.
There's a 32, regulation of professional conduct.
Yes, I'm good with that. I'm within that.
So here's an example where keyword searching may or may not help depending on your keywords, and it's good old, as I was chatting with Brandon, English language problem, that there are just too many ways to express. So some of you have been looking under update. You wisely didn't say update and update and update. Some of you did supersede, so that was a creative alternative. But as I was suggesting, that's pretty specific. What if an attorney didn't find a relevant statute? It has nothing to do with updating, but it's the same concept. So here's where you would have to have chosen the word that's used by the key number, which I don't want to just give you because that defeats the purpose of at least part of the exercise. So what you need to do is try, I saw some of you on Google, which is fine. Some of you did try searching the key numbers, which I suggested isn't my favorite way, because again, you need the exact right word, which is why I think searching cases. So what you want to think about is, and I was using this example, where are you very specific factually? Because you're rarely going to find a case on your exact issue. You might not find a case where a judge talks about updating. Judge might talk about shepherdizing. Now, I'm not saying that that's the right word. I actually don't think it is. So a parallel might be in our assignment example. Your client wants to advertise polyphenols. I don't think you're going to find statutes or when you do the cases assignment on polyphenols. But what would be that's a very specific factual term. What would be a broad, especially when you're searching facts? You might want to start specific. So starting with superseding and updating might be good, but when that doesn't work, and you've been at it now for a while and it's not working, try being less specific. So what would be less specific factually? An attorney, lawyer, can't get, that's pretty much what we've got, right? Probably malpractice scenes, I think. I think you all agree malpractice scenes. So our factual is the updating. So think about other ways, less specific ways. And this, you want to sort of go through this analysis as I've sort of done for each part. And again, teaching issue spotting. So what are thoughts on other ways, other terms? We've agreed attorney or lawyer is good. Probably malpractice is good. Maybe due diligence is good, but that other factual part of what the attorney did or didn't do. Okay, that's definitely, we're in advanced legal research. And do the advanced legal part because we're assuming legal already. Other, okay, that's even broader, but yeah, typically what I've said is first go for your facts. So try to update, but I think that's not working for many of you. So take a step back and then a step back. If you need to. If you only need to take one step back, great. If that doesn't work, then take a second step back. Is that making sense? Well, if you found the one good case, then you don't have to worry about it. If you found, so, whoops, sorry. Try not to. Okay, so you found attorney and client, and you went with. Okay. So if you think, see what I would do, and what I would do as you narrow into the key number, again, look at that table of contents for the key numbers, because you might find one that sounds good, and in looking you might discover another one.
Oh, you mean discover something here?
Are we doing, is this the correct way to do it? Because I'm doing it that way.
There's no correct way.
Right, there's no
That's
correct
the
way.
problem.
Right, but the way that you, or you just like that, basically. What's your
Okay, so
experience?
here I am.
I know.
At some point, when I find one good case, and I say, okay, attorney and client, and you found 129, I would go to this key number breakdown and say, okay, 129, actions for negligence. What else here looks useful? And just, I mean, within this section of duties and liabilities, because that sounds relevant, just read through their what? 15 here, it'll take you 2 minutes to read through. Are there any others? Maybe you want to use both. Maybe there's better.
Should we be like browsing those instead of searching for cases?
The cases, searching for cases.
How do you know it's going?
Okay, searching for cases is what I recommend to get you to at least the topic, if not the topic and a subdivision. So hopefully searching for cases at some point, and I think a lot of you got at least this far, got you to attorney and client. And depending on the number you got, so for instance, Crystal got 129. So what I suggest is go to 129 and see, is 129 in a subdivision that looks promising? 129 is duties and liabilities of attorney. That sounds promising. So in that subdivision, I'm going to see what else is there that might look better or at least as good. And I might use 129 and something else, or if I find something, oh, wait a minute, I found another one that's much better. Let me focus on that one. It depends. If 129 is in a subdivision that doesn't look so great, I'm going to look at some of the other divisions because I think attorney and client probably is where I want to be. If that's what you conclude. Retainer and authority, no, that's no good. Office of attorney, I don't know, I might scan to see if it sounds relevant, but duties and liabilities is the one we... Compensation, this is definitely not about compensation, so we can skip that. And lien, this doesn't have anything to do with an attorney's lien. So you see the process of analysis. I want to at least get to the topic, hopefully to a subdivision. And again, that's the one good case. And it may not be a great case. It may be a one sort of good case. But if it gets me to a topic that sounds like it makes sense, and then looking at the subdivision, hopefully that's a good subdivision. Maybe not. I'll look at the others if not. Is that helping?
Yeah.
Thank you.
Allie, Danielle, is that helping?
So for number 4 though, it says to check the key number filter to narrow the search. If these other ones aren't showing up on there, like should we skip that step and just go and look at the broad list of all the topics, subdivisions?
Okay, this, in truth, I didn't anticipate everybody having such a hard time, which is fair enough. That's my lack of foresight. You want to look, I would say actually definitely look at the table of contents. So when I do this workshop next time, I'm adding a table of contents step to it. So make that a 3A or a 2A, wherever you want to do it. I don't care what order. So I would say 2A, look at the table of contents for key number and see if you find any better or at least as good that you want to follow up on.